My name is Daniel Vaswani, and I'm the lead attorney at Virtuoso Criminal and DUI Lawyers.
So, you've been arrested for a third DUI. I'm sorry. Let me tell you why. Things are getting more serious. In fact, much more serious. The way that it is determined whether or not you are responsible for a third DUI is if you have 2 prior DUI convictions prior to the third DUI arrest within 10 years of the arrest that just occurred. In that situation, it's a third DUI. Now, if you've been convicted of a third-time DUI, you will more likely than not see a 5-year probationary grant. In some situations, if the courts are feeling generous, it may be 3, but you can very much expect to see a 5-year grant. Now, outside of probation, there will be fines and fees that will be imposed. At a minimum, those fines and fees will be approximately $2,000. As you recall from our expungements video, you can only expunge a conviction off your record after you've successfully completed the probationary term and paid off all fines and fees and restitution. Keep in mind, that means if you have a 5-year probationary grant, you cannot expunge the conviction off your record until that period passes. On top of that, you will also be subject to the alcohol terms, what I mentioned in the second-time DUI video. If you haven't seen it, I'm going to tell it to you again. Number 1, you cannot drive unless properly licensed and insured. You have to submit to a chemical test when asked by a peace officer, and you cannot drive with a measurable amount of alcohol while on probation. On top of that, you will likely be told to abstain from the use of alcohol and not to frequent places where alcohol is the primary item of sale. That means no going to bars. The most strenuous part of a third-time DUI is the mandatory jail time component. It is a minimum of 120 days. You need an attorney in this situation because if you have qualified counsel, there are sometimes opportunities to avoid actually seeing the inside of a jail cell. Through residential treatment, outpatient treatment, and potentially electronic monitoring in the form of GPS home detention and an alcohol monitor called a SCRAM device or a continuous alcohol monitor. There's also a DUI school component. That DUI school can either be 18 months or 30 months. I said 30 months. In some situations, some counties actually offer programs to reduce the jail component by completion of the 30-month program. Not every county offers a 30-month program. It may be hard to find, but speak to qualified counsel if you're interested in potentially examining that option. Now you know how the courts operate as it relates to DUIs, but obviously driving is dealt with by the DMV. The DMV is taking action against your driver's license and requiring you to install ignition and lock device. Like I mentioned to you, a DUI is a 2-point offense at a minimum, and it can be more. On a third-time DUI, there will be a minimum of a 3-year revocation. Of that 3 years, you will be required to install ignition and lock device in your vehicle for a period of 2 years. If it's a DUI with an injury, it's again a 5-year revocation. And of that 5 years, you'll be required to install ignition and lock device in your vehicle for a period of 3 years. If you have a refusal on a third-time DUI, it's actually a 3-year revocation with a hard no drive, followed by 2 years of ignition and lock device. A refusal and a DUI with injury have some significant consequences on a third DUI. Often, if there's a DUI with injury on a third DUI, a DA's office will invariably charge you with a felony. If you have questions about this, please call at 8336-NO-JAIL.